There are several possible outcomes at each VPO hearing. The respondent must be served with a petition for protective order before a hearing can be held. If the respondent has not been served, the judge will ask if you want to proceed with your case. If you do, the judge will issue an alias order. This authorizes law enforcement to try to serve the respondent again, and you will receive a new court date. You will need to take the alias order to the court clerk's office and fill out a few additional forms to complete the process. You will receive a new court date that will take place in about 10 to 14 days. Make sure your mailing address with the court clerk is correct. They will mail you a new notice when a new hearing is set. If the respondent does not come to your court, you can ask the judge to proceed with your case and enter a final VPO because the respondent was properly served but failed to appear. This is called a default. The judge may not grant this request, but you can always ask. Your case may be continued. The judge will not hear any of your evidence today. Your emergency order, if it was granted, will stay in place, and the judge will order you to return to court on a different date. Your case may be transferred. If either party has filed a custody or divorce case or tells the judge that they plan to, the judge will be required to transfer the VPO case to the same judge assigned to the custody or divorce case. Having both cases in front of one judge is helpful because you will only have one hearing date for both cases, and only one judge will decide all the issues pertaining to your family. If you are granted an ex parte emergency order, it will stay in place until the next court date. The judge may hold a hearing and issue a ruling on whether you should have a final protective order. It is impossible to say for sure whether a hearing will occur on any given court date, so it is always best to have all your evidence and witnesses at each court date. Under Oklahoma law, you have a right to request a final VPO hearing if it has been 6 months since the respondent was served. If there are criminal charges pending against your abuser, your VPO case may be continued. This means your ex parte emergency order will stay in effect, and you will get a new court date. Under Oklahoma law, you have a right to request a final VPO hearing if it has been 6 months since the respondent was served. At this time, you can ask the judge to hear your case even if criminal charges are still pending. After each hearing, the respondent is required to stay in the courtroom for 5 to 10 minutes after your hearing so that you can safely leave the building. Make sure you go directly to your car and leave the area. If the judge orders a final protective order, read it and be aware of what it says. If the respondent violates the order, report it to your local police. Criminal charges may be filed against the respondent for violating an emergency order or final VPO.